Hi, everyone. I'm Steve Altition, Director of Client Partnerships here at Pacific Cascade Legal. And today we have Real Estate Collaboration Divorce Specialist, Professor Kelly Lisa Murray, and she's going to talk about how unique and high value assets can get complicated when divided in a divorce. Kelly, how you doing today?
I'm doing well. How are you, Steve?
Oh, I'm doing very well. It's our first day of rain in Oregon in like 20 days. So
Oh,
it's kind of an oddity,
well,
but
good for
we're
you,
liking it.
apparently.
We're liking it. So, Kelly, before we start, can you just talk a little bit about yourself and how you came to be in the position and doing the stuff you're doing?
So I'm an edupreneur now. I have degrees from Stanford University and Harvard Law School. I have an Illinois law license for over 30 years. I was a litigator, and then I was law faculty at Vanderbilt University for 18 years, retired recently, moved away from Nashville. And what was my side project as law faculty is now my main focus, and that is wealth dispute resolution. And I train judges and lawyers, I train financial professionals, I train mortgage and real estate professionals, and then I educate the public on issues that affect mainly family disputes about wealth related items like assets and money and all of that, because it's so important to get it right. What I have found through all the thousands of cases I have researched and spoken about for over 15 years, that there are patterns that can help people prevent mistakes, prevent post litigation, meaning a post divorce action or even a trust contest or other probate disputes. We can prevent a lot of this with just planning, documentation, and making sure you have the right team in place. And from all of my research, you've got to start with the right lawyer who is the quarterback of the rest of your team. So if you have unique or high value assets, you absolutely need to start that way.
I love that. I love that. It's great advice just right there. Um, we obviously do a lot of divorce here, and we've come to realize divorce is never a simple process.
Right.
There's always something. And, the division of assets, I know is sometimes one of the most challenging aspects. And, so what I'm going to start with is, what are some of the assets that are or can be particularly complicated, uh, and kind of start talking about them and how to make them less complicated. But what drives that complication of some of these assets?
One would be unique assets. So something that you don't see all the time. And we're going to be talking today about timeshares. Steve, you raised that issue. And even though I train real estate professionals and mortgage professionals to help folks in divorce, and that's the RCSD you mentioned at the top. That training I started in 2008. So I'm training them how to help people going through a divorce and how to help lawyers with folks going through a divorce with those assets. I had not looked at timeshare. So timeshare is a unique asset in and of itself. And one of the issues is it even real property? So I found that fascinating. So that's a uniqueness. And then you can have high value, but not an active resale market. So even though something has high value on paper, in divorce, if it has to be sold, the actual value may not be what gets on the marital balance sheet. It may be the liquidation value. So those are just two of the patterns that have stood out in putting this together. But we're going to be looking at art and wine, valuable wine collections, and firearms, which actually has a lot of case law, and then timeshare.
What seems to kind of connect all of these in my brain is that not only is it difficult for, the clients, the people who are dividing, the attorneys, but these are things that judges don't see every day.
Absolutely.
And yeah, and that makes it harder because judges, as their job, they get used to certain things. And so it's much easier. They have less difficulty uh, kind of working out the division of property. But one of these things come up, and So it's like almost having to train the attorney, it feels, or the judge, it feels like. It
Oh,
just really
absolutely.
interesting.
It is because, and I have cases where it's not the judge's job to generate evidence. The judge can intervene and suggest things if the judge has separate knowledge of, so let's say it's a timeshare and the judge happens to know timeshare law. But what I'm seeing in the case is when one side or both present zero evidence, it's not the judge's job to fix this. It's not the judge's job to save you from your own lack of evidence, your own bad evidence, or your own bad deal. So, what you want to do if you are the one who wants this asset or wants this asset to be valued highly in the marital balance sheet, you have to do the due diligence. And again, your team is critical. You're going to need, so depending on the asset, what type of professional could value that asset. And what I'm seeing in the case law for all of these types of assets we're talking about today, if one spouse presents evidence and the other has none, where's the judge going to go? Well, this is the only evidence in the record. That looks pretty good. Because if there's nothing to rebut it, and that would be affirmed on appeal because that standard is abuse of discretion. Well, the judge isn't abusing discretion if only one side presented evidence and it was admissible. So
Yeah.
what you want to do in preparing is if this is your issue and this matters to you, you need to take the lead. The other side's going to react to your evidence and they may come up with evidence. So I've seen cases where these valuable assets, no evidence or competing experts, use mine, no, use mine. And then the judge has to figure out who's more credible, what was their methodology, and that can happen with other assets. But you also want to see how did the other side hire an expert? So if it's their asset and they hired an expert, you may need to hire an expert. If it's their issue, if they want it and you don't really, that's not what you really want, you can just see what they're doing and just match their level of evidence. You don't have, if they don't get an expert, you don't have to either. If if you can match it or or if you don't mind their number. Because
Yeah.
basically if there's only one side presents evidence, that's probably going to be the number.
Oh, yeah. It's like you say, there are these different things that have to happen. And what we're going to talk about today, the thing that first comes to my mind is don't do it by yourself.
Don't.
It's one of those situations where you don't have the legal knowledge, you don't have the persuasiveness, you don't maybe not even know how to get the knowledge. And so when you said like you need a team, that's exactly correct. But let's
It,
talk about, and I was looking at some of your stuff and it was just fascinating how art and art collections or antiques, those kinds of things can really get complicated fast.
Absolutely. And it comes art especially because is it, do you have a Renoir or do you have more modern art that still has a lot of value, but a different understanding of its value? And it depends on the market. Can it be resold? Are you going to an auction house or are you selling it locally? That will change the value, or you want to make sure. So, for example, if the insured value is $10,000, but it can't be sold for $10,000. You don't want $10,000 on the marital balance sheet. I call that monopoly money. If you're the one awarded this asset and it's $10,000, which means you're giving up something, let's say part of the pension to keep this art and you can't sell it for $10,000, you're shortchanging yourself. So that's why you need the team to help you get the documents, get the strategy together, and then look at the numbers because resale is everything. These assets aren't liquid. And if they're hard to sell, they're going to stay illiquid until you determine where the market is. So
Yeah.
in art, we have found courts can get creative, but only based on valuation evidence. One side has to show the court this is going to be difficult to sell, this is difficult to value. The court's not going to just make it up, but courts are getting creative and they're also very practical when they look at these cases.
You got to wonder if the judge is watching Antiques Roadshow. Because,
You know, that would help. I
yeah,
That outside knowledge could definitely help folks or help the court suggest some evidence, some additional due diligence, because each side has the obligation to identify and value assets and identify and quantify debts, and you can't just point fingers at the other side. So you won't have any leverage after divorce if you didn't do your part before.
uh, it also feels in art like the emotional tie you have to a particular painting or
Oh,
collection
absolutely.
is really driving in a lot of cases their need to keep that and maybe they're paying for it.
Well, there's a New York case where it was the wife's art collection and it wasn't famous, but it was valuable. And she presented evidence of its value. And because it was a marital asset, the the husband had a marital interest, but it wasn't being divided 50-50. And so they set a number of 10% of her valuation. That wasn't resale, that was just like insured value. So that's higher than possible resale. He was owed 10%. She would have to liquidate 29% of her art collection just to give him 10% in cash. That's an example of why you need your team to get the numbers on your marital balance sheet correct. Because the value, 10% cash, she had to liquidate 29%. So you don't want to just use the insured value. But it suggested to me, and Steve, you and I've talked about this before, there's an opportunity, isn't there, to negotiate if
Yeah.
he's owed 10% in cash, but she has to liquidate 29%. Maybe there's some leverage to suggest he accepts some of it in painting so he gets more than 10% and she gives up less than 29%. What do you
Yeah.
think?
Yeah. I mean, it's funny because, if there's two cars in the family or three cars in the family, usually, the judge sort of boxes that off and says, okay, you get this car, you get that car, and then let's move on to something else. But art can, just by its very nature, I think, and its difficulty to evaluate and maybe sell, it's kind of hard to do, but maybe it's a good idea. And you had talked about, and I want you to talk a little bit about this case that you had where a judge got very, I don't want to say it, unique in how to decide the division of property in an art issue.
It it was I find this I'm a research nerd. I find this fascinating, and this case delivers in the interest and the uniqueness and the creativity. This is a high net worth divorce in Ohio, and apparently there's a local rule in Ohio. So it wasn't just the judge creativity. The whole court system there has a local rule that if you can't otherwise divide the asset, you have to flip a coin and pick one at a time. That's how
Yeah,
they divide expensive and unique assets in this county in Ohio. And so they have assets in the United States, but also in France that had to be divided. The wine is in the United States and France. They had art in the United States and France, and it was all going to be done with a coin flip. So I certainly hope that there is some automation involved because you need to set up. It's almost like you need a merge document to say this is what I want in my order. Because what if the other person picks your number one first? What do I want next? That could be very time consuming, especially if the lawyers are doing it. So hopefully there's some automation involved.
it's like fantasy baseball.
Absolutely. You're picking your fantasy team with really expensive items like art
Yes.
and wine and jewelry. But so I could see a judge coming up with that. There's a famous photograph that has been recirculating again. It's from the 1990s, and you can tell from the hairstyles and the clothing and the look of the courtroom that it's the early 1990s. And there's a pile on the floor of the courtroom of Beanie Babies, and the husband and the wife are both kneeling in front of this pile, picking one Beanie Baby at a time because back then that was valuable. So this
Yeah.
has been used before, and that is a very famous internet meme that floats around every now and then.
But it part of I think what you do a lot is to get your clients to the point where that doesn't have to happen, where it isn't
Right.
kind of a pure chance thing. And we've had several cases about wine collections, and that is fascinating. And you brought that up. And can you talk about wine collections and their sort of unique, you know, ways that they can be divided or evaluated? Because that's not something that is just a universal. There's no Kelly book on wine.
Right. Well, one thing to keep in mind is if you have a valuable wine collection, and even before divorce, so just as a responsible owner of a valuable wine collection, you really should have it valued if that requires appraisal so it's insured properly. If you have the wine in your house, climate controlled and all properly stored, you still need to know your homeowner's insurance policy may limit a single item's value to $2,500. Well, if you have a bottle of wine worth $20,000, it's not properly insured. So that's my first caution after reading these cases. You should already have that in place, which means in the divorce, you're just handing that information to your lawyer
Yeah.
because you were a more secured owner of these valuable items like wine. And then the next thing in divorce, if it's contentious, what happens to the wine? Is someone kind of secreting some of the wine away? You would need an inventory, and there are some case law on that where a high asset divorce in Connecticut, the wife did an extensive inventory. Their wine collection was worth $600,000, and it was
Whoa.
stored in climate controlled wine cellar in the marital house, which was a very expensive marital house. She inventoried everything, time-stamped video, which you can do. Obviously, even more professional is even more reliable, but she was able to document what was there. He hired movers, and most of the wine was gone. She redocumented it after the movers. He claimed, so it's a $600,000 wine collection. He claimed he'd only removed about $200,000 worth of wine. She was able to prove that's not the case from the moving company's records because he insured one case of wine for $250,000. That was just one case. They took over 8 cases.
Yeah. Well,
So the documents, so that's how she was able to prevail on that issue because of the documentation from third party movers.
yeah. And it's something that I just don't think you, even in a divorce, are, you know, thinking about. You're getting a divorce, you're angry, you walk in, you pull out a nice bottle of wine and not thinking about, oh, am I dissipating assets?
You are absolutely right. That's how I look at it. If you're so unlike other assets, if you're drinking an expensive bottle of wine, you that could be considered dissipation, wasting marital assets that could be sold. So if you drink a $20,000 bottle of wine, but I
Oh,
can think of it, lawyers, we can always think of the exception, right? I can think that if you were trying to land a big business deal and the owner of the company that you're trying to do business with is at your house for dinner and you pull out the $20,000 bottle of wine, you might be able to claim you were trying to increase the marital estate.
yeah.
But most of the
Oh,
time it is that way. And there's a case in Louisiana, intermediate appellate court in Louisiana, where the wife's it was he said, she said, but the wife said he drank some of these expensive bottles. And the court had a really equitable result in that case. The court accepted the wife's valuation of the wine collection. So that was the high end of the value. So it took the highest value of evidence in the record and then awarded all of the wine to the husband and giving her offset of different assets, which means if he really
uh,
did drink the wine and the collection was no longer worth her value, he's the one who gets less. I thought
yeah.
that was a great result.
Well, I love that. It's the who was it? Was it King Midas who cut the pie? Someone would cut the pie, and the other person would, choose which piece.
That's right.
I like
Well, and
that.
that actually is fair. If he didn't drink it, he
Yeah,
gets the full value. If he did, well, he already used some of that marital asset. And I'm fascinated because when I'm looking at financial assets, not uniquely valuable, but actually, stocks and retirement accounts, I've seen that happen the same way.
oh
If it
yeah.
can't be valued, if it can't be valued, you just give it to the person who the evidence shows is the one who allegedly reduced it,
Yeah,
mismanaged it. And just as a sidebar, you are not penalized in court for making a good faith but poor investment decision.
yeah,
But there is, especially for any valuable item, if you mishandle it, if it gets damaged or destroyed because you didn't insure it, you didn't properly box it up, that could be considered, that could be held against you. And then the other side gets more of a different asset to offset that reduction in the marital estate.
yeah. Uh, Wine. One of the things when we had talked about this, and I'm thinking, it's not, I guess, just wine, but but a lot of these divorces can go, especially complicated ones, possible they can go 2, 3 years, and wine ages, and it either can age and become good or it can decline
Right.
in value. And so, I mean, if I had a big, huge collection of wine, I would want to get this thing resolved right away. And that could be, other things. I mean, there may be a painting that right now is that's a hot painter. Um, you know, let's get this thing valued now and or before it loses value. I mean, that seems to be in some of these things. The value can go up and down.
Well, and that's why the timing of valuing assets in divorce is heavily litigated in every state. Do you value it at the time the divorce petition was filed, at the time of trial? And it depends on the asset and depends on the state and depends on who's arguing what. Sometimes there's some uniformity, but yes, an asset can appreciate or depreciate after its valuation. So if the court rules that okay, it's going to be valued at the time the divorce petition was filed, if that asset goes down in value, you've got monopoly money right there.
Yeah. Wow. The other one that you brought up, the other type of asset that you brought up that just I was kind of going, huh, really? And then I'm thinking, this is really fascinating how these things may be valued or actually split, and it's firearms and guns. And
Absolutely.
the first thing that came to my mind was, you know, uh, there may be a party who's not allowed to own a gun.
And there's case law on that. We have an answer for that. So that has been litigated in more than one case where if the firearms are marital, it's no big deal for the court to award it to the spouse eligible to own and possess those firearms. That would be equitable division or even community property split. That would work. But what happens when some of those firearms are separate property? If it happens in a state where separate property remains separate, then that looks like an issue. Well, it wasn't an issue in this one case because the court it was also a domestic violence order. So there's a domestic violence order, and the court awarded all of the firearms, including separate property firearms, to the wife because the domestic violence order was against the husband, because the public policy of safety overrides the how separate property is usually handled, and that again is a just result.
Yeah, yeah. I don't know if it's all states, but I know that a lot of states, these FAPAs, these restraining orders come with a uh, turn in your guns.
They
Yeah.
should. That just for everyone's safety, that just makes sense.
Now, however, even without that, it would seem that guns would be really interesting. I have a cousin who was helping someone trying to evaluate, I don't know, 13 rifles that from all the way back to the, Revolutionary War. And it's
That's
got to be tough.
amazing.
There can't be a whole lot of people that
But they're probably
evaluate
museum
guns.
quality. If they're museum quality, that's a different market. If
Yeah, yeah. I
that's
mean,
fast,
and
just to be able to see them, just to see them would be fascinating. So yes, lawyers get to experience some uniqueness in every level of cases, but certainly in this category, you would.
yeah. Are guns and firearms treated just the same way as any other piece of property if it's inherited or gifted? And in normal law, or it's like, okay, I may have gotten this before, may have been mine, but now we're mixing it together and it can become marital property. But you know, if someone brought 3 guns into the marriage, and they all went out hunting, is can that change kind of how firearms get listed?
I have not seen a case on that. And just thinking about how commingling and transmutation works with any kind of asset. Simple use seems like it wouldn't be enough. This is exactly why you need a lawyer. If that's your issue,
Yeah.
that has to be specifically researched. I did not specifically research that, but I did find you were mentioning the estate and inheritance. There's a case where the husband and wife died as a result of the husband's causing a car accident, allegedly. And because they were the others involved, so the third parties also involved in the accident, they were suing the husband's estate. Well, the firearms were going to be 50% of it, if it was still the husband's estate's property, would have been subject to the judgment for causing the accident. And the wife's estate argued that she inherited 100% of all of the guns, just as she survived him a little bit, and so her estate was claiming that it survived it, that the guns were her estate's property. And if that was the case, then the negligence lawsuit couldn't reach 50% of the guns of the firearms value. So I thought that
Oh my
was really
gosh.
fascinating. Then that was the decision. And then it was the burden of the estate to prove that it had or did not have the interest. So
Wow.
so we can talk about the interesting facts. Sometimes the legal issue may be a little procedural. It's very important, but it's not as fun to talk about.
Let's go to, God, we're just blowing through our time. This is so fascinating. There's so many questions. But let's now talk about timeshares. And I did bring this up because
You did.
it was in our family. Um, a person who died had a timeshare, and the state probably went on an extra, I don't know, 9 months only because they couldn't get rid of the freaking timeshare. It's such a different sort of thing. I mean, is it personal property? Is it real property? Is it property at all?
I didn't even know that was an issue until you asked me to look into this. So that's what's so fascinating about it. You can sometimes find the answer straight away, which is every lawyer's sigh of relief, right? Oh, great, there's an immediate answer. But actually, the case I found is in Texas, and it was only an issue for the case. So here's what happened. The husband was claiming that the wife was too late, that the statute of limitations had expired. She was trying to enforce the property division regarding the timeshare. If the timeshare was real property, like owning real estate, the legal term for real estate is real property. So the legal issue was if this timeshare value was real property, she was too late. Absolutely, everybody agreed from the date she filed her complaint to enforce the statute of limitations to enforce real property disputes had expired. But if it was personal property, she had more time and she was timely. And what the court decided won't really help anyone else, but the court decided that the court decided that that the burden to prove whether it was real property or personal property was on the husband and that he failed to present sufficient evidence to meet his burden. So we get it's not helpful to anybody else other than to know you have to meet your burden of proof if this is your defense to an enforcement action.
Yeah.
I find it interesting. Hopefully other lawyers will find it interesting. It's just not as fun to talk about in a chat.
I like it. I like it. Yeah, it's when you look at it, it's is it an investment? Is it a because you don't really own anything,
Wait, well, if
even
you
though they
think about
tell
the
you.
bundle, the sticks in the bundle of rights. So first year of law school, we learned about the sticks in the bundle of rights. It's like a half stick.
Yeah,
And I have another case that valued a timeshare. So in a divorce, the timeshare was valued $50,000. But because they have to pay $9,000 a year, that reduces its marital balance sheet value. That's
yeah,
so you don't own it. You get to use it sometimes, and you have a significant annual financial obligation.
yeah, yeah. I mean, those things can become a minus value.
And have you seen the advertisements? There are advertisements of companies that will help you get out of a timeshare because it's so difficult.
Yeah, absolutely.
So
Wow.
thank goodness those exist because I've seen it litigated where they're litigating, let me out of being obligated to pay this $9,000 a year for something I'm not even using.
Wow. Well, Before we go, I do want to allow you to talk about or ask you to talk about if someone wants to get a hold of you before if they have any of these issues. But I think what we've talked about makes me think more and more that it's not just the general art can be difficult or this that can be difficult. It's nuclear. It's each thing. Two pieces of art can be completely different and have to be treated completely different. Or I
Yes.
mean, it gets that granular to me, it feels like. I need people like you and teams that can work that know how to do this. Because boy, this is a swamp. It could clearly get to be.
So what I do, I focus on enforcement of property division. And the best time to enforce your property division is preparation before mediation. So
Yeah.
there are protections you can put into a mediated settlement agreement that will help you enforce later. And there are things you can omit from your mediated property settlement agreement that will make enforcement harder. And of course, if you've agreed to give up certain assets, you're right, the art, some of the art and some of the wine, but you're keeping the gun collection, and then the other side doesn't give you the gun collection, you want to be able to enforce that. So that's
Yeah.
my current legal scholarship. That's my focus. And so that's enforcethedivorce.com. But on the other side, I've been teaching real estate agents and mortgage professionals how to help you and your legal team and your divorce financial team get the documents and information you need to make an informed decision about house's value. Can you keep it, which is different than should you keep it, which is different than will you keep it.
Yeah.
So all of those things, all of that preparation, we really help the folks I've trained help you prepare for mediation about the house and about the mortgage and about liens to generate an informed decision, but an enforceable settlement. And that's key because if you can't enforce it, did you really, you didn't get the benefit of the bargain, to use the legal term. So that's divorcethishouse.com. And I've created an ebook about our session today, and you can get that at pcl.divorcethishouse.com. And I'll say that again, pcl.divorcethishouse.com. You can download the ebook and have a, so you don't have to take notes of what we were just talking about.
Good. I love it. I love it. Wow, Kelly. Thank you so much for being here today to talk about it. This is unique, high asset stuff, gets complicated fast, needs a really good team. And you were able to talk about it in a way that these complex issues can be understood like even someone like me. So that's a great job. So thank you for being here today.
Thank you so much, Steve.
Oh, it was great. And everyone else, thank you for joining us. If anyone has any further questions on today's topic, well, you can post it here and we can get you connected with Kelly. You can call Kelly or get connected by yourself as well. And until next time, everyone, stay safe, stay happy, and be well.